When I started law school, I was planning to join the Foreign Service, actually. I was going to be a government lawyer, so I wanted to do public international law, war and peace, use of force, international criminal law. And I got kind of disillusioned with it in law school. And at the same time, I had a really charismatic contracts professor who was not only a great teacher, he was one of the leading scholars of his generation in the United States, Alan Farnsworth. And I'd had zero interest in business before that. But he really kindled an interest in contract law as a puzzle, as a policy question, as a technical discipline. And finally, I found a way to put the two of them together. And so my main area of focus is international commercial arbitration, which is the marriage of contract law and international law. What I really like seeing is the exploding of myths, right? The correcting of misconceptions. And just about every law student comes into law school with a pretty fundamental misunderstanding of law, which is that people think, and this is true for the whole, the general public, people think that law is a body of rules, and once you've learned those rules, you know the law. But of course, even a month into law school, you start to realize that isn't true. And so what for me I think is the most satisfying thing, and it's one of the reasons I like teaching first-year courses so much, is to see students come to this sort of disturbing, but also thrilling realization about just how contingent and how uncertain the law is. That law isn't so much logic as rhetoric, right? It isn't something that just is out there. It's something that we use, right? It's a tool of social organization, and it's a tool for individuals to assert their own rights and interests against each other, against the government, and so on. So that's what I probably find the most interesting about law for myself, but also what I find the most exciting to try to communicate to students. Well, there's a kind of a running theme through all of my research, which is that what I'm most interested in is how the law adapts when you have people from different backgrounds, different legal backgrounds, different cultural backgrounds, different linguistic backgrounds, meeting each other on the international legal stage. So a lot of my research is informed by a kind of a sociological or socio-legal perspective. I wrote a book about the sociology of the international arbitration field, and that's something that really continues to fascinate me. So a lot of my research projects, one way or another, relate to that. I could tell you a little bit about what I'm working on right now. One that I've just submitted is an article on translation in international arbitration proceedings. What's the role of translators? What's the legal impact of mistranslations? And it concludes with a sort of a set of recommendations, maybe even a call to arms to the international arbitration community to take issues of language more seriously and to take steps to protect the integrity of the evidence in international arbitral proceedings. A second paper that I'm in the middle of working on that I just presented at a conference last week is a sort of a more big picture, big think kind of article about the future directions of international commercial law and how I think it's evolving. And basically my prediction is that increasingly as the divisions between national laws disappear and the law globalizes, that doesn't mean that the law is unifying. A lot of people kind of equate globalization with unification. But what I actually see happening is a different reconfiguration of the law away from division by national borders towards a commercial law that's divided up by industry sectors. So for example, a finance contract, a contract for commodities, a contract for software, a contract for oil or minerals would be governed by different bodies of law, even if the contracts are functionally similar. A third piece I'm working on right now is a more theoretical one about the role that international law should play in the decisions of investor-state tribunals. This is something that's very controversial recently, and it's become politically a very hot button. Just witness the recent, I don't know what the right word would be, sort of scandalization of investor-state arbitration, especially in Europe, which came very close to sinking the Canada-EU Comprehensive Economic and Trade Agreement. Based on the objections of a small portion, a province of Belgium called Wallonia, that almost put a stop to the entire treaty, mostly on the grounds that they object to the way that investor-state arbitral tribunals had made decisions affecting the regulatory policy of states. So I'm making an argument about how investment law more narrowly fits into international law more broadly, which would allow investor-state tribunals to take account of broader interests: international human rights law, international environmental law, and international labor law, all of which would increase the democratic legitimacy of investor-state arbitrations, and as I argue in the paper, also fits with the fundamental structure of arbitration from a theoretical point of view. So it's a kind of a theory applied to practice paper. Now, in all of those things, what I'm looking at is how the international community, and in particular the legal decision makers within that community, should be rationalizing the competing interests of different cultures, of different economic entities, of different business configurations, and so on. And that's kind of the core fascination that ties together a lot of the different strands of my research, which are otherwise more varied. My research writes for a variety of different audiences. Some of it is for an academic audience, some of it's for a practitioner audience, some of it's for a policymaker audience. And one of the things I like about a law faculty and legal research is that you can bring those different strands together. What I write has mostly to do with commercial law, and in particular with a relatively small and obscure corner of commercial law, which is arbitration of international commercial disputes. But it has a lot of broader social ramifications, the way businesses conduct their business. And one of the fundamental questions is how much of that is going to be done privately, right? Outside the control and outside the scrutiny of the government in the person of its courts. Right? So one of the fundamental questions in arbitration is the extent to which arbitration is autonomous from court oversight, from regulatory oversight. And there's a real tension, because on the one hand, a lot of countries, Canada included, have a policy of being pro-arbitration. It's more efficient, it clears up court dockets, and everybody wants to get a faster court date. And it also allows businesses to have their disputes resolved by specialized experts. You can get a higher quality decision, you can get a more efficient resolution of the dispute. But on the other hand, there are concerns when you start to take all of this activity out of the public eye, because most arbitrations are confidential. So just earlier this year, the Lord Chief Justice of England and Wales made a big annual address, and one of the things he said is that the increasing popularity of arbitration is depriving the courts of sufficient cases to develop the common law, to keep pace with technological changes, to keep pace with evolutions in business practice. And so a lot of my research deals with how we resolve this tension. On the one hand, to preserve arbitration as a specialized, high-quality, efficient mode of dispute resolution. But on the other hand, to find ways to account for the public interest, both within arbitrations and in the legal system as a whole, as arbitration relates to more public forms of dispute resolution, especially in court. So something I'm really excited about that I'm about to start working on, I haven't actually yet, is a guidebook for Canadian judges on international arbitration law. It's a project that's going to be co-sponsored by the Canadian Committee of the International Chamber of Commerce, which is the leading arbitration institution for international commercial disputes, and the National Judicial Institute, which is the main body for judicial education in Canada. And the idea is to provide a practical guidebook to international arbitration law issues that arise in Canadian courts. So let's say you have a litigation that's been started, but the contract contains an arbitration agreement. The court is going to have to decide, is the arbitration agreement valid? And if it is, they're going to have to dismiss or suspend the lawsuit and send the parties to arbitration. Or maybe there's an ongoing arbitral proceeding, and the court will be asked to preserve evidence that's located in Canada, even for a foreign proceeding. Or a court might be called upon to remove an arbitrator who's been accused of a conflict of interest, or to enforce an arbitral award that was rendered in a foreign country. This is a kind of a technical area of law, and it's still a little bit obscure. Even a lot of commercial litigators don't have much experience with it. And certainly people who are now experienced enough to have been raised up to the bench probably didn't get much exposure to it, either in their previous lives as practicing lawyers or since they became judges. So we're going to be putting together a guidebook. It'll have some basic background on international arbitration law in Canada, And it'll be kind of a step-by-step guide. So whichever motion is raised in front of a judge, they'll be able to flip to that section of the guidebook and find a list of the relevant statutory provisions, a little explanation of standard practice, and most important, a checklist or flowchart that would allow them to guide their own inquiry as to what sorts of facts need to be established and what legal rules they should consider in making their decision. So the idea is I'm going to be working on it over the next few months. It's then going to be shared, the draft, among senior members of the International Arbitration Bar in Canada and people from the Judicial Institute. And hopefully late next year or early the year after, it'll be published by the National Judicial Institute.